do you think this YNW Melly case could have went different if Melly would have went to the hospital with boiling in the body?
Well, it's anytime that you change any specific fact in any case, everything is going to turn out different, all right? Because the prosecutor is going to line up their case, they're going to line up their witnesses based on the facts of what happened that night. But if we have a situation to where Melly shows up to the hospital and says, oh shit, my boy just got shot, all right? It's going to be a situation to where they're going to want to hear his statements, they're going to want to hear what he has to say, and it's going to make him look a lot less culpable, all right? But I'm not in a situation where I'm telling anybody it's a good idea to lie to the police. My position is it's a good idea just to not talk to the police. Because even if you're in a position, okay, where you find yourself like Melly, okay, where you're charged with something major, even if you had nothing to do with it, it's always a bad idea to talk to the police. Because these people, they are tricky, they are trained, they know how to get a statement out of you. So even if you tell them something like, you know what, I got there, but I got there at 3 o'clock, and the police then say, well, you know what, you actually got there at 3:30. You're lying about that. What else are you lying about? So
Right.
As far as him being at the hospital and not being at the hospital, that's absolutely going to make a huge difference. But no matter what position that anybody ever finds themselves in, there's no upside to talking to the police under any circumstance.
Right. So basically just a quick breakdown of what you basically saying is just it always makes you look less guilty to show up when it's a situation like that. But even if you show up, you don't have to talk and you shouldn't talk. You should possibly show up and have a lawyer meet you there. Call your lawyer and say, hey, I'm on my way. Meet me at this hospital.
Well, that's exactly right. And, whenever there's any type of police questioning, and let me say this, all right? If you call the police, they should help you, all right? They should help you. Whether they do or not, that's a completely different story. But if the police call you, your first thing that you say to them is, I'm happy to speak with you, but I want my lawyer present. Lawyer, okay? Because, like I said, anything that you tell the police is going to be one more piece of information that they didn't have before, and they sure as shit are going to use that against you in some fashion.
Okay. All right, I'll move to the second question. Is it common that law enforcement track your cell phone, and is it accurate?
Okay. Usually if we're talking about a state case, okay, you're not going to be dealing with wiretaps. Okay, so if you're worried about somebody tapping your phone, and if it's a state case, usually they're not going to be doing that. The only time that you ever see and this is kind of a little bit different than what you're asking me, but I'll get to where we're at in a second. Okay. If we're talking about a state case, you usually don't have to worry about wiretaps. Most of the time, but not always. Okay, if we're dealing with a Fed case, it's much more common for the feds to be able to tap your phones. That's usually where you see phone taps coming in from. But what both the state and the feds can do is if they want, they can track your phone. And it is incredibly easy for them to do that because all they've got to do is say, we've got a suspect here. They go to a judge and they get a subpoena for your phone records. And then they can see where you were and they ping it by cell phone locations, by towers. So they can't give an exact location of where you're at based on your cell phone, but they can have a really close area of where you might be based on where your cell phone is pinging. So if you are a suspect in a crime and they want to know where your phone was, they can absolutely get a warrant for the cell phone companies to get your location. And this is something that comes up all the time. And the thing is, we all carry cell phones on us, okay? Our cell phones have got all the information about us, pretty much that there is to use. And it's very easy for the state, for the government to get a subpoena for your cell phone, okay? Not only your location, but every single thing that's on your cell phone. Any messages that you've had, any phone calls that you made or anything like that, if they want to get it, they're absolutely going to get it.
Okay. I think that one was really straightforward. 3, YNW Melly lawyer has a mugshot going viral. Do you think that reflects poorly on Melly's case?
Listen, if I have to hire a lawyer, all right, hopefully I'm never in the position where I need a lawyer, but if I have to hire a lawyer, I want a lawyer that knows how to throw a punch, right? So the idea of her mugshot going viral or whatever it may be, I don't think that's going to have really any effect on this case. I think it's more embarrassing for her to have her past drug up and to be, blasted everywhere. But as far as an effect on this case, I don't think the jury's going to say, we're going to find Melly guilty because his lawyer was in trouble at some point. I don't see that as a huge issue.
Okay, because I'm seeing a lot of people kind of look at it and be like, well, if she has a criminal history, quote unquote, what are they two criminals conspiring together to get another criminal off? Basically, how a
No,
lot of people positioning it.
you know, I think that's a fair argument. And you know, when I'm standing in front of a jury, I want to present myself as the most credible person in the room, so the jury believes what I'm saying. Okay, the argument that I'm making, I want them to really listen to it. So maybe I'll be concerned if the jury knows about that. But you know, this isn't a situation where the lawyer was arrested for, you know, theft or lying or stealing or anything like that. My understanding is it's just an assault case. So
Okay.
that if she's standing in front of a jury, I don't think that makes her any less believable because her past crime didn't involve any dishonesty.
Oh, okay. 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 Melly's lawyer gave a theory that possibly YNW Bortland was the shooter. To me, it sounds like they're throwing Bortland under the bus. And do you think that would make Bortland inclined to cooperate?
Well, that's a great question. Number one, fantastic questions here. But when you are sitting at a counsel table and you have the government trying to put your guy or your girl away for the rest of your life, or even trying to sentence him to death like they're trying to do, whatever it is that you need to do to get your guy out from under it, okay? Your loyalty is to the guy sitting next to you, who you represent. And if somebody else has to go down in that situation, if you have to pin it on somebody else, that's what you got to do, okay? Whether they're friends, whether they're buddies or anything like that, whatever defense that you have to get your guy out from under it, to defend him, you use that.
Okay.
Now, that's different than the idea of snitching. Okay? My position as a defense attorney is that I don't like snitching. I don't represent snitches. And the reason for that is two. Number one, I don't want to see anybody get hurt, okay? Because people know real quick who's turning state's witness, and that word travels everywhere. I don't like the idea of, once I get my guy out from under it, not being able to walk down the street safely. Number two, and just as important, is that if you work a case hard, you work a case the right way, usually the resolution that you can get will be better than the resolution it would be if the guy is snitching, okay? Right. So, as far as snitching goes, I don't like it. I don't like anybody being in danger. And like I said, usually at the end of the day, we can get further by working the case the right way rather than flipping somebody.
Right. Okay. Why do you think the judge denied the mistrial, and what do you think the outcome of the trial may be, guilty or unguilty, from the stuff you know?
You know what? Based on what I know, anybody that says that they know what a jury's going to do is lying. It doesn't matter what the case is. It doesn't matter what you feel like the case is incredibly strong for you or against you. You never know what's going to happen. The cases to where I've walked into trial and I've thought, holy shit, there's no way we're going to win this, were some of the biggest wins of my career. So anybody that says, I know what this jury's going to do, they're full of shit. They just don't know. Okay, you don't know how a jury's going to react in the courtroom, in the jury room, what they find to be the most important pieces of evidence. As far as what I'm seeing out of this case, I think the prosecution is going to have a very hard time proving this. I think they're going to have a very hard time proving this. The fact that they don't have the gun, okay, they don't have any DNA on the gun, they don't have any fingerprints on the gun, they don't have any ballistics or anything like that. I think that the prosecutors really got their work cut out for them on this. You know, and as far as the mistrial, you know, these issues kind of come up, and I can't say whether the judge made the right decision or the wrong decision, but I don't think it was a great decision as far as the defense went. You know, a mistrial on this would have been very good for them.
Right.
But what I would say on this is that anytime that you have a mistrial, whether it's in the middle of a trial or you end up with a hung jury at the end where the jury cannot make a decision, that's all mistrial. That gives the prosecutor a chance to retry everything. They would just start back at the beginning. Any time that you have to try a case for the second time, as the defense, it's much harder because the prosecution gets another bite at the apple.
Right.
They see what the witnesses, how the witnesses acted on the stand, what they testified to, and that gives the prosecution a second chance to actually do better. So a mistrial in theory sounds great, but the fact is that if the prosecutors wanted to, they would just start the case right over again. And that makes it harder for the. So it kind of cuts both ways. I'm sorry for the long-winded answer.
It's all good. That's what we're looking for.
Yeah, right. So is it good for the defense? Not really. Is it bad for the defense? You know, they just move forward with it. They move forward.
Okay, now there's some new breaking stuff,
Yeah.
right? So now it's a deputy trying to come in, and he trying to basically testify that basically he believed that it's $50,000 on his head, and he have to wear a mask to court to testify. And then I think it's something they talking about with the Sixth Amendment, where you have the right to face your accuser, but it's not. He not even basically saying if this ties into Melly. He's just saying in general. So what do you think about that?
Okay, so that.
One more thing. It looks like the judge is going to allow him to do it.
So, as far as the Sixth Amendment says that you have the right to face your accusers. Okay. So technically, they do have the right to face, you know, this cop that's taking the stand. He's wearing a mask though, and to me, if I'm the defense attorney, I'm jumping up and down saying that that's absolutely crap. Absolutely crap. They said that they want him to wear a mask to protect his identity because he's getting threats or whatever it might be. And my position is that when I'm cross-examining somebody, I want the jury to see their face. Because what the prosecution wants is for their witness to be as credible as possible. And when I'm cross-examining that witness, the jury's watching that witness. The jury's watching what their eyes do. They're watching whatever ticks their face make when they're being asked questions.
Right.
Information that you can get. And it's just like, you know, when you talk to anybody, if you're asking a question and you know they're lying, their face does weird things.
Right.
I'm gonna want the jury to see exactly how that guy's reacting. And the fact that he gets to wear a mask to testify, that right there puts the jury at a huge, puts the defense at a huge disadvantage. And one more thing on that. They're bringing this guy in to testify as an expert on gang-related activities. Anytime that an expert comes in to testify on gang-related activities, this is something that is just dripping and just covered in racism when somebody is testifying about gang activities.
Right.
They'll be talking about, you know, guys on the street throwing up gang signs or whatever it might be. But the thing is, all right, this is down in Florida. Take a look at any Florida sorority picture. They're throwing up signs themselves.
Right.
Are they calling them a gang? No, they're not calling them a gang. But they get to interpret these actions based on the narrative that they want it to fit. Do you see what I'm saying?
I know exactly what you said.
That's what it is. Okay? So anytime that anybody is testifying about, you know, gang activity, all we're doing is talking about a group of people that happen to be around each other, and they say, well, shit, that must be a gang right there.
Right.
And that's not what it is. There's a racial undertone to gang expert testimony every single time.
So to add another point to that, right, you know, when I do the Chicago do's and don'ts, I did one called like Yeah, Aight, where it's different interpretations of Yeah, Aight, right? So a lot of times when you get a lot of those cops on the stand or just people in general who gang experts, they're not from the culture, so they don't understand the nuance of it. Well, I could say I could be talking about basketball and I could text, yeah, I'm gonna kill you today. Well, I'm talking about that in the context of playing basketball,
and all
but you take that in the context of that.
All of a sudden, you're a suspect.
Right.
That's exactly right. That is
exactly.
And so, yeah, like I never, you know, anytime that anybody's testifying to gang activity, it doesn't add up. It doesn't make sense. And like I said, you know, there's so many racial undertones that go into it to where, you know, it's just not right. It's just not right.
Right.
And the other thing is, they could have brought in anybody to testify that they are an expert on gangs. But the fact that they have to bring in this one guy who's not involved in the case, not involved in it at all. they have to bring in this one guy and he has to wear a mask. That's bullshit. There could have been 50 other people that they picked to come and testify that wouldn't have to wear a mask. So as the defense attorney, I'd be jumping up and down on that.
Yeah, man. And so another thing that they brought into the case this morning that I saw this morning. So as far as Melly's cell phone, they were having a problem proving it was his because it's not in his name. Well, they introduced today some things from his mom where his mom was texting him in the past. She called him her son. She basically spoke about how they were having issues with the two guys. And also he sent out a picture of his ID allegedly to someone else. So if they get that into the case, what do you think that does for the defense, and how does that turn the case of them being able to prove that it's his phone?
You know, it's hard to say in that situation. Number one, the jury's got to actually believe that it was his cell phone. And it is for anybody to pick up somebody's cell phone and shoot off text messages, you know, or whatever it might be. You know, they have to prove that it was him that was actually using that. And if there's any connection to it, the judge is probably going to let it in. And then it's up to the jury to decide whether it's credible or not. Because what's going to come down to, and really what any criminal case comes down to, is it credible? Is it believable? Does the jury believe what's going on here? Okay. And again, we're talking about a cell phone to where they can't say for sure that it's his cell phone. We're talking about a detective coming in with a mask. You know, I've got a lot of credibility questions about all of this. And if I'm a juror, I'm asking what's going on here. And if a juror to me is saying, I don't understand, this doesn't make sense, I don't believe this part, that's good for the defense. That's what the defense wants.
Yeah. I think that the defense actually made a great point this morning, because they had the defense attorney was asking him, and he said, hey, did you sit outside the court this morning when you came here? And he was like, yeah, without that mask. And he was like, yeah, for about an hour. He was like, did you sit outside the courtroom? He said, yeah, for about however long it took for me to come in. He said, did you wear a mask? He said, no. So he was like, you're so concerned about your life and the attempts on your life, but you sit in front of the courtroom where people who you say may have this alleged amount of money on your life walk in and out and are able to see you, photograph you, or whatever. And he basically ended up saying, well, I just don't want to be live streamed across the nation. But I look at it just like a lawyer or a cop or a firefighter. That just comes with the territory of your face being seen.
That is 100% accurate. And that's part of the job. That's what you sign up for. That's what you sign up for. And if you're going to do it, and if you're going to do the job, you're going to do the job the right way, you're going to testify the right way, come on in with it. Take your mask off. Take your mask off. Let's see who you are. If the state is asking the jury to believe this person who they're trying to asking this person who is trying to put Melly away for the rest of his life, and the fact that he can't take his mask off, why would you believe him? Okay, why would you believe him?
Right. Yeah, it's crazy to me that he would be allowed to do that. And I actually think, even though the jury may not believe him, I think if they can do, like, if the prosecutor have a good closing argument, they can make the case that, yo, he's such a threat that this cop has to wear a mask in there for his protection. And what do you think about his friends who don't have the law on their side? So I think it's totally unfair.
That's a really interesting point. So I was trying a case a couple years back, and the jury, because every time you try a case after the verdict, if the jury wants to stick around, the lawyers can go and talk with them. Right. And one of the things that the jury told me on this specific case was, your guy seemed like he was a very dangerous guy sitting in court. Seemed like it. And that was something that they took into consideration. It's like, well, shit, okay. So I think that's a really interesting point that you make, to where if the police are scared of this guy, that might be something the jury takes into consideration too. You never know.
Yeah. And that's one of the questions that I wanted you to answer too. What should your demeanor be in court? Because a lot of people get prosecuted just based on how they're acting. The jury don't care what's being said. They're looking at him, like you said about your client. They say he looks dangerous. So it doesn't matter what else is being said. He looks dangerous.
how you present in court, how you present to a jury makes such a big difference. Okay, so if anybody's sitting courtside at a trial or in court in any way, okay, you want to be sitting there and you want to look as calm and as relaxed as possible. Okay, you're going to be able to take notes during trial if you are in trial, but I tell everybody, jot notes. Okay, don't sit there and write a novel. Jurors don't like that. Okay? Just take it all in. If you lean over to talk with your attorney, make it quick. Okay, it's not the attorney doesn't want to hear from you, but the jury is going to be watching the interactions. And the other thing is that if you're talking to your attorney's not hearing what's going up on the stand. All right, so it's, even if you want to get your attorney's attention, be quick about it, but let your attorney cook. All right, let them do their thing. So while you're sitting there in court, you want to look as relaxed as possible. You don't want to have a lot of reactions. If you hear something you like, don't get excited about it. And if you hear something you don't like, don't get down about it. If you hear something you don't like, don't shake your head and say that's a bunch of bullshit. Just take it all in. You want to be like water sitting at the table.
Right, just going with the flow, basically.
That's it.
That's it. I know you got other stuff to do. Any more questions they send me, I'll get them to you. But just like give a quick breakdown of what that is, and then also give your social where they can follow you.
Yeah, sure. It's Attorney Nicholas Robinson. You know, as far as my Instagram page goes, really anybody that sends me a question, I'm going to try to get it answered. So if anybody's got anything, let me know and I'll get that popped up as soon as I possibly can. You know, and I think that's about it, man. Love the work that you are doing. All right, keep it up. I'm so happy to see how successful you are with everything. I think you're doing a great job. I'm so happy for you.
Man, I appreciate it, and I also appreciate, you know, sharing your knowledge, because you don't have to. It's time. You're a lawyer. You do other things. So sharing that knowledge with the people who need it the most, the people who are underserved, that's great. I appreciate it.
Well, here's my position. Anything that I can do to put somebody in a better position, I'm going to try to do that. All right. And this isn't something to where, you know, this is a money thing or anything like that. I don't want to see people get rolled on that don't need to be.